Hi, and welcome to CPR's YouTube channel. I'm Russ Bleemer, and I edit Alternatives to the High Cost of Litigation, CPR's monthly newsletter that's published by the International Institute for Conflict Prevention and Resolution at altnewsletter.com. I have had the honor of gathering our esteemed panel here to look at big commercial conflict resolution news here on YouTube and elsewhere on your internet. You're going to see double-digit numbers of this panel's YouTube analysis here on the CPR Institute YouTube channel, and it joins more than 100 cutting-edge ADR topics, analysis pieces, and interview features. We are back. It's October 2023 because a month ago, the U.S. Supreme Court granted cert in an arbitration case, and like most of the many arbitration cases the court has heard and decided, this one's likely going to have a profound effect on how individuals and companies use the courts and private resolution processes to resolve their disputes. Yeah, this one involves individuals. It's not a business-to-business case per se. The Bissonnette versus LePage Bakeries Park Street case. I'm going to put some links below in the introduction on the screen. The Bissonnette case is an employment matter in which truck drivers seek to file suit because they say the parent company here, which by the way makes Wonder Bread, which you all have at home in your pantry, it says the parent company misclassified the truck drivers as independent contractors and the company violated state and federal laws. It deducted operating expenses that it charged the drivers to participate as independent contractors in delivering the company's baked goods. And also, as we've seen in these cases before, there are the customary accompanying overtime pay issues. The legal issue for the Supreme Court and for our panel is whether the drivers are exempt from the application of the Federal Arbitration Act, which under Section 1 exempts from arbitration, quote, contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. We're going to be talking about that phrase today. The lower courts, as has been customary, have sent the drivers to arbitration, but this is a new era, or at least it appears to be, for arbitration cases. Maybe in 2018, this panel would have, gathered here. We would agree this case is going to be sent to arbitration, or we probably would have said the court isn't even going to take this case. Well, now the court's accepted Bissonnette, and it's expected to be argued in January or February. As of this recording, the court hasn't set an argument date yet. The fact that the case is at the Supreme Court stage probably traces to a recent trend of plain Federal Arbitration Act language readings, plain FAA readings that stem, or at least appear to stem, from a 2019 opinion by Justice Neil Gorsuch. That was the unanimous 8-0 case of New Prime versus Oliveira. In Oliveira, which we've talked about, and you'll see here on YouTube with this group, there was a long-haul truck driver. He was also an independent contractor. He was permitted to use that FAA Section 1 exemption to go to court. It was a class action case, no less. And he went to court rather than arbitration over wage claims. In other words, the driver's contract of employment under FAA Section 1 tracked the wording of the exemption. Now, the court always reads the plain meaning of the FAA. It's got decades of history of that. But the unusual part in this case was it didn't compel arbitration. It was in favor of the employee who didn't want to arbitrate. That plain reading of the statute turned out wasn't to be a one-off. Justice Clarence Thomas last year, another 8-0 decision, unanimous, a case called Saxon versus Southwest Airlines, which we've discussed here on YouTube as well. It permitted a Chicago ramp supervisor for Southwest, who occasionally handled baggage, to use the transportation workers exemption to avoid arbitration. It held that even though there was no travel across the state line, the worker and those in her class, this too was a class action, they were transportation workers in interstate commerce. Now, we noted in June 2022, when we talked about this case, this issue was going to return in new forms. So we got that right. That's what Bissonnette is. We also noted that the implication of Thomas's unanimous opinion was that a job-by-job, task-by-task analysis with the effects on interstate commerce is going to be the new requirement for exempting workers from arbitration under FAA Section 1. So now we're at the Bissonnette case, and Bissonnette and his co-workers, they drive trucks for a bakery. But the appeals court noted that they weren't in the transportation industry. Okay, they work for a bakery or a bakery distribution company, depending on which original plaintiff it was, and where in the hierarchy of the Wonder Bread company they are. Again, FAA Section 1 exempts from arbitration contracts of employment for seamen, railroad employees, or other class of workers engaged in foreign or interstate commerce. So despite Justice Thomas's Saxon analysis on the job, the appeals court here insisted that there was an industry requirement on top of the job requirement. In fact, the Second Circuit, the lower court in the case, reheard Bissonnette after Saxon and came up with that holding. I am delighted to be here with people who can explain all this. In New York with arbitration analyst Philip J. Lurie Jr. of the Lurie Law Firm. You see his link down below. Phil and I here in New York are joined by our two Dallas friends. Angela Downs is at the University of North Texas, Dallas College of Law. She's a professor of practice and assistant director of experiential education. Her link is down below. And finally, Richard Faulkner, also in Dallas. He's a solo attorney, arbitrator, mediator in Dallas, Texas. It doesn't look like the arbitration world has changed, or maybe it has. Isn't this an easy call for the court here, with the idea that there is some sort of change? Isn't the court going to look at this and just say the Second Circuit misconstrued the transportation requirement from an early seminal arbitration case called Circuit City, which had a transportation requirement? Isn't the court just going to say you just misread Justice Thomas and all of us less than 2 years ago, the unanimous Saxon court? And isn't this case just going to be headed for a Gorsuch-esque plain language reversal? Aren't the drivers going to wind up going to court instead of arbitration? Or is all this my fantasy and my illusion? Is it me? Is there, beyond the job analysis that Justice Thomas talked about, beyond the interstate commerce requirements that are in the statute, is there an industry requirement baked into the Federal Arbitration Act? And these bakery drivers, well, they're most definitely not in the transportation industry, and maybe they don't merit that exemption after all. Phil, what's going to happen when this is argued and decided in 2024?
I think we're going to see pretty early on this term a decision reversing the Second Circuit. We're dealing here with a requirement that really appears nowhere in Section 1, and we're doing that in the context of Justice Thomas's opinion in the Saxon case, and there is language in the Saxon case which, and not to mention its holding, that refutes what the Second Circuit did here. I mean, under Saxon, as long as the workers within a class of transportation workers engaged in foreign or interstate commerce, then qualifies for Section 1 exemption. That's what Saxon said. Now, granted, Saxon was a case that involved Southwest Airlines, which happens to be in the transportation industry. However, the court said nothing about that in terms of it being a requirement for the applicability of Section 1. The court actually in Saxon put together a pretty easy test under which, quote, any class of workers directly involved in transporting goods across state or international borders falls within Section 1's exemption. That's pretty clear. Surely in this case, the workers in Bissonnette are transportation workers because a large part of what they do involves driving commercial trucks and distributing goods to retailers in interstate commerce. And so just as the ramp supervisors in Saxon were classified as transportation workers because they frequently loaded cargo on and off airlines or airplanes, so too I think will SCOTUS probably rule that the plaintiffs in Bissonnette are transportation workers because they frequently drive trucks transporting goods in interstate commerce.
Yeah, I just want to add, Flowers is the parent company here. They're not named in the title of the case, but that's the parent company, which owns the distribution companies and bakes the Wonder Bread and all.
Yeah, I think they're a party, but they're just not the first. But the reasoning of Saxon, if you go through it, there's a rejection within it of industry focus as opposed to a worker focus. And looking at it, it makes it clear that it's irrelevant whether or not a worker is a transportation worker. I'm not like the Second Circuit, by the way, got that interpretation from the Dr. J or Julius Irving case 72, which was, which involved, which was decided even before Circuit City, and Circuit City didn't really directly address whether that applied or not, but after Saxon, it seems pretty clear that there's no place for that kind of an extra component of applicability of Section 1.
It just seemed like Circuit City
Yeah.
was a predominant thought in the Second Circuit opinion writers' mind. They really invade a huge amount of importance over it. It's almost as though Circuit City subsumed Saxon. Saxon was a subset of it.
Yeah, and then the court also relied on not only that. I mean, Circuit City said it was you had to be a transportation worker. So Circuit City doesn't get into that requirement at all. And what happened, I think, in the Second Circuit is that we had this in 1972, this transportation industry requirement, and then that just kind of stayed with us. And then when Southwest came down, there was a real reason for wondering whether or not the Second Circuit's cases in that regard are consistent with current law. But the Supreme Court concluded that Saxon fit within the exemption because, quote, Saxon is a member of the class of workers based on what she does at Southwest, not what Southwest does generally. And the court, I put that emphasis in there, but it's pretty hard to argue that there should be this industry requirement when the court is just rejecting it at every turn. And they, for example, the court also rejected the argument that the ramp supervisors should be deemed transportation workers because they work for an airline and therefore engaged in the customary work performed by an airline. That's another industry-based test that the court rejected.
Well, that was the point that I had just made about the fact that the job itself was going to be analyzed, and that sort of weighs against the actual business that was conducted. It seems easy when you're talking about an airline, but if you're going to look at the job, that's why it seems like bakery employees, if they're doing a transportation company's job, would seem to fit in just fine.
Yeah, and I could cite more stuff from the opinion, but basically there's no textual hook in the statute. Whether even putting aside Saxon, I mean, where does this industry requirement come from?
Yeah. And now on that point, Phil, the status of the employee, there is still some questions there. I'd like to discuss. Professor Downs wants to talk about the independent contractor status of this employee. That, in a sense, is in Bissonnette is a repeat of the New Prime unanimous decision from 2019, where it was also an independent contractor, same year.
Absolutely, absolutely. And you've got these, the crux of it. You've got the workers who were claiming really that they were misclassified as independent contractors. That they didn't have the protections owed to employees, such as minimum wage and overtime. And we're really finding that they were not fitting the bill as employees. And because of that, this arbitration exemption would extend to them. And so, they are really saying, this is how y'all need to look at us. We were hired to do this very specific function. We're falling under the exemption of the FAA. And so there's no reason for us to be held, as part of this bigger picture. And so I really think that the Supremes are going to look at what's been laid out as in Saxton, and I can't see them really going around it. And I think that they're going to use the Bissonnette case as a way to extend really the folks who can take advantage of the arbitration exemptions.
Yeah.
So
Do you think this opens up, because the court has one of the app cases still in front of it. I can't remember which one, but there are cases against Uber and all around in the circuits. Is that or are you saying you think a decision here is going to open the doors to those to get up there, or
I
cut
think,
them off
yeah,
maybe entirely?
depending on how it goes, but I think that the court has been giving us signs with the Saxon case and some of the other cases that came out recently to, to say that, this arbitration exemption, it's probably going to be extended to more folks. And if that's the case, then that's going to affect cases going to court. And so I think it's going to have a dramatic effect for cases that are kind of winding their way, such as Uber and a lot of the other cases that are out there.
Okay. I'm sorry, contracts of employment under Section 1. So that is a leader to a lot of the other litigation that's out there about the status of those drivers, and in turn the status of whether or not they have to arbitrate. Rick Faulkner is concerned about these plain language challenges to other parts of the FAA, and says, I think he's thinking we may be on the verge of some other types of cases coming in beyond employment.
Oh, I think that is certainly true. The very textualist approach by the court over the last few years, especially if you go and look at some of the things like the New York Rifle and Pistol Association constitutional case involving the Second Amendment, the court has been careful to look at the language at the time of the enactment of either a statute or that constitutional provision. And frankly, I find it highly amusing in a weird way that the Supreme Court only takes 1% of the cases that CERT is filed on, but when it comes to arbitration, they're taking about 3%. And if arbitration is the wonderful thing that so many folks in the business community say, and I've said similar things in the past, you wouldn't see so doggone many people fighting like the devil to avoid it at all costs.
Rick, where did that 3% come from? Who is tallying the arbitration cases? That's a good one.
Stats on that, and I'll try to locate it again and send it to you. But having been a professor of ADR law, I tend to read very strange things. My wife describes it as arbitration porn, and I tell her it's better than that because it's all funny. But
that's why we have such a friendship.
Yeah, if you look at what is really,
I thought that's what we were creating here, but
if you look at what has been happening, I think you've got other areas that open up some real interesting issues, particularly with regard to jury trials. But before I go exactly there, I would point out something, and it is, if in fact these plaintiffs, Mr. Bissonnette, and I grew up in New Orleans, so I pronounce things French. If Mr. Bissonnette had applied for membership in the Teamsters, I will bet you he could be an active member of the Teamsters Union, which might well militate in favor of him being in the transportation industry. But setting that aside, let's look at the jury trial issue. Because in Section 4, there is a requirement that if the making of the agreement to arbitrate is in dispute, upon demand, there shall be a jury trial. And like any law professor, I went back and looked at the debates involving the adoption of the FAA, and even more so, the debates involving the original New York arbitration statute, which was the predecessor of the FAA. And one of the concerns there of the proponents was providing a mechanism for a jury trial to ensure the constitutionality of the FAA. And I think that is a relevant inquiry. And when you add what we're seeing now with the court's focus on text and focus on looking at what the understanding was at the time of the enactment of the statute, I think there's a potential for a lot more to be done in terms of raising challenges that go to juries who I strongly suspect are not going to be particularly enamored of arbitration. And when given an opportunity to find that someone has not agreed to arbitrate, they may be tempted to do that. And let's take a look at how broad these almost infinite arbitration provisions have become. If you try to take an Amtrak train, if I bought a ticket for everybody on this call, I supposedly have agreed to arbitrate all of your claims for personal injury or death. And if you happen to bring along a child, I'm supposedly able to agree that the child would have to arbitrate claims against Amtrak. You have numerous companies that have said that, like AT&T, oh, well, if we acquire a company, or if there's an assumption, or if there's an assignment, then you've agreed to arbitrate with that new entity too. And at some point, these become extraordinarily attenuated. And I think the court is going to find it will have to address these issues. And if the making of the agreement to arbitrate is squarely an issue, and the court persists with this textual approach, I have a suspicion we're going to see a lot of jury trials on that issue, and that some of the federal judges will quit making these determinations on their own, because those cases and determinations were predicated upon the strong federal policy in favor of arbitration, which, as we now know from recent cases, is in fact simply treat arbitration provisions like any other contract term. So this could be opening the door to many years of litigation. And remember, folks, we now have companies like Uber trying desperately to get out of arbitration. Samsung, which was recently ordered to pay an initial deposit of $4.1 million in the Illinois biometric case, and could, according to some of the things I've read, potentially be on the hook for $100 million in arbitration costs. And so we're seeing arbitration continuing to metastasize into areas that nobody really thought about, but that a textual reading of the law seems to say is required. And there aren't many companies that are thrilled to get a $94 million bill from the AAA or a $100 million bill just to start the arbitration process. So we arbitration commentators and advisors and consultants are going to have a lot of things to do in the future.
You know, Rick, I think you bring up such a good point. But with looking at what you've just described, I just don't think our courts can bear it if we get an influx of litigation. We're still, the courts are still recovering from COVID backlog. And if we
preaching to the choir with a wife as a district
absolutely
judge.
And if we get an influx of cases that are being sent instead of going to arbitration, which is supposed to streamline the process, provide more of a voice for the parties, and then go to traditional trial court, we're going to be at a standstill, and cases are not going to be heard in a timely fashion.
I agree that's an issue. Arbitration is theoretically an issue of consent.
Absolutely.
The sheer fact that so many people are making so clear that they never consented, would never consent, don't ever want to consent to arbitration makes this a very interesting set of issues. And I agree. I mean, having been a trial judge, we didn't lack for cases. And I talked to some of the federal judges that I know well, Judge Mazant in the Eastern District, Judge Gilstrap, Judge Jordan, and their average docket is over 2,200 cases per judge. And nobody will accuse federal judges of being lax about moving their dockets.
Oh, no.
And that's on the rocket docket. So, maybe if arbitration is handled differently, it will become desirable, as opposed to having so many would-be plaintiffs fight to avoid it. And maybe if the Supreme Court does, address the FAA and allow more exemptions, maybe that will tamp down the conflicts with folks who have a problem with arbitration. Perhaps, perhaps there might be, some form of silver lining that might come out of this if this is the case for the court. Yeah, we're seeing mass arbitration cases where, all of the major providers led by CPR have tried to find solutions to some of the plaintiffs' attorneys, claimants' attorneys filing 10, 20, 30, 40, 50,000 individual demands for arbitration in the Samsung case, putting the cost of those arbitrations onto a business that kept hearing, oh my God, class actions are so bad. And now in Samsung, it seems as though the defense attorney are expressing wishful thoughts of returns to class actions.
When you had mentioned, Rick, Samsung at the top, I wanted to slip in a little annotation. But you all got to it, Angela and Rick, on the mass arbitration point. Again, we're on CPR's YouTube channel. If you go to cpradr.org, you will see some of the tools and processes in the employment mass arbitration area, specifically the CPR Employment Mass Arbitration Protocol. It's cpradr.org. On the news side, if you go to that same website, we do have a blog called CPR Speaks. I'll put a link down below to that as well. We did look at the Samsung case a couple of weeks ago when that stunning number came out, and that was a news story we couldn't ignore. We are running short of time that YouTube is going to allow us to post, but I kind of poisoned the well here, and fortunately, Phil and Angela were only too happy to drink from it, and they think that the court, they seem to agree with the premise that the court is going to take this case to reverse it in some fashion. Rick, you went right to the big pictures and didn't tell us what you thought was going to happen with Bissonnette. So if you'd like to do that and then give us a last word, we'll go around.
I think the U.S. Supreme Court is going to find the Second Circuit's reasoning was half-baked, and it will be a unanimous reversal.
Then we're unanimous here on the screen. Angela, do you have any last thoughts?
I don't, but as always, I think we're gonna buckle up and we're gonna be watching to see what happens with this case.
Bill, do you want to finish what you started?
Yeah, no, I think I finished what I started, but I do want to point out there are two issues, kind of lurking issues that were raised by the Second Circuit that may become relevant in cases in the future. One was there was a vertical choice of law question where the choice of law clause said that Connecticut law would apply as long as it's not inconsistent with the FAA, and Connecticut arbitration law doesn't exempt these the workers at issue in Bissonnette, and so there was a question whether arbitration could and it could actually proceed under Connecticut law, and that question may come up on remand. The court realized that it was kind of a thorny one. Now the other one was that this was a case where you had a litigation, and then there was a motion to compel that was granted for all the claims, and so the district court, instead of granting a stay under Section 3, what the district court did was it just dismissed all the cases. Now that was what actually allowed the appeal, of course, to the Second Circuit, and Judge Jacobs wrote about that, and he seems to be of the opinion, and I hope I'm not misquoting him, but that perhaps the Second Circuit should reconsider whether a Section 3 stay of litigation is mandatory only where one party or another requests it. There was no request by either party for a stay in this case, so the district, if the law had been that the stay is mandatory, then there wouldn't have been an appeal. And not only that, but the court said there, subject to some further interpretation of the Badgerow case, it may be that the retaining of jurisdiction would give the district court jurisdiction over subsequent motions to compel, motions to vacate or confirm arbitration, etc.
And the nature of stays is something this group has talked about. You'll see that on YouTube. And I think I'll take from Phil's comment that this case itself could be further proceedings on that. It's not unusual to see these arbitration cases return to the Supreme Court. One of the cases pending, by the way, is the Coinbase case, which was the last time we got together last June. On that note, thank you all very much for getting together. Watch us at CPR ADR on the CPR Speaks blog, and here, follow the links below. And we will return to this. I expect we're going to see an argument in January or February, and we will be back to talk about that and the decision next year. Thanks for joining me, everyone.
Thanks, Russ.
Thanks.
Thank you, Russ.